Welcome. This is the second plenary session titled Varieties of Secularism. I'm grateful to our panel this morning. They introduced the question and some of the problems that arise with addressing religion, secularisms, and law. And today, in this afternoon session, we hope to delve more deeply into this question of what is secularism? How is it understood variously in different countries and even within a country? As Professor Jakalic mentioned this morning, really one has to talk about secularisms and not just secularism, because there are many different conceptions, certainly even within any given country. As Professor Philpott mentioned, there's certainly ways of looking at it in terms of having a negative or a thick sense of secularism as a strong policy on having a social sphere where religion is absent, or as he referred to as a positive one, or perhaps a more thin version where there's phrased more in terms of neutrality or equality. And we appreciate Professor Jakalic's comments on this alliance that sometimes we miss as well when we look strictly at political systems and ignore social movements and social actors where religion and secular ideas can combine and make a difference in society. This afternoon we have an eminent panel. I won't take more time away from them. We look forward to hearing them. I'll just briefly say a few things about them now and then let each of them speak in turn. Our first speaker will be Professor Elizabeth Shakman Hurd, an associate professor of political science at Northwestern University in the United States. She's written extensively on secularism in the global scenarios. Second, we'll hear from Professor Jean-Paul Willaime, who's the research director at École Pratique des Études at the Sorbonne in Paris, France. He's a sociologist who spent many years looking at questions of religion and society. And finally, we'll hear from Professor Effie Fokas, who's a research fellow at the Hellenic Foundation for European and Foreign Policy in Greece, and also teaches at the London School of Economics. Each of these panelists brings a long and distinguished record of publishing and thinking about these issues, and we're grateful to each of them for the different angles and perspectives that they bring, looking at both at global issues of secularism and also delving deeply into individual problematic situations of how secularism should be understood in a particular context. So I'll give the floor to each of them, and then we should have some time for questions at the end. Professor Hurd.
Thank you so much. Hi, everybody. I'm going to try my best to keep you awake after a long and delicious lunch. So what I'm going to do today is turn things upside down a little bit and turn this analytic of secularism on its head and talk instead about varieties of establishment. My paper is called Beyond the First Amendment, Religious Engagement and the Politics of Establishment. I think this allows us to move beyond what has become a rather tired focus on degrees of separation or accommodation, freedom or unfreedom, and instead consider how various forms of governance, state governance and others, manage, reform, marginalize, all of those activities and human goings-on that are understood to be religious. And I'm going to draw here in my thinking, although I won't read you any long, boring quotes, from a recent volume which was just published by Ashgate called Varieties of Religious Establishment, edited by Laurie Beeman and Winifred Sullivan. My own work, as some of you may know, has been on the politics of religion and international affairs and U.S. foreign policy. I have just finished a book which analyzes the politics of what has been called the return of religion to international affairs. By this I mean and refer to the newfound momentum for the promotion of religious freedom, religious engagement, as it's called, advocacy for the rights of religious minorities, and related such endeavors. I am interested in the understanding of religion that underlies these efforts, and I'm interested in their consequences for the people that are governed by them. The title of the book is Beyond Religious Freedom, The New Global Politics of Religion. Today I'm going to focus on a tiny little piece of that and talk about the politics of U.S. government-sponsored religious engagement overseas. And I'll tell you what that is and what the programs I'm referring to in a minute. But first I'm going to preview my 2 points that I'm going to make about these programs. First, in the United States, these activities are not new and can in fact be located on a long historical timeline, much longer than is often understood to be the case. Second, the analytical tools that scholars have relied on to understand these actions and activities, such as secularism, the separation of church and state, freedom and unfreedom, the legality of the extraterritorial application of the religion clauses of the U.S. First Amendment to the Constitution, all of those standard vocabularies I'm going to suggest are simply inadequate to the task. We need a new conceptual vocabulary, we need a new framing. So, if that's the case, why is the Varieties of Establishment framework any superior as an analytical tool? And that's what I'm going to talk about today and suggest that we think in these terms. Let's look at what's actually going on. Let's start on the ground, so to speak. In 2013, as many of you know well, the U.S. State Department launched an Office of Faith-Based Community Initiatives to engage with faith communities outside the United States. Speaking at the launch of the new office, Melissa Rogers, Director of the White House Office of Faith-Based and Neighborhood Partnerships, stated that, quote, strategic engagement with religious leaders can help us to break cycles of violent conflict, end quote. In the lead up to the creation of the office, President Obama assembled a large working group on religion and global affairs. And its job was to develop, quote, a comprehensive map of how our government engages religious actors in foreign affairs through USAID missions, embassies, and departments across government, from the Department of Defense to Health and Human Services. As Josh Dubois of the White House Office of Faith-Based and Neighborhood Partnerships said, as a result of this work, we've seen new courses in religious engagement at the Foreign Service Institute, new efforts on religion and global affairs at state, and a renewed focus on the intersection of religion and foreign policy across the U.S. government, end quote. The U.S. now has a strategy on religious leader and faith community engagement. The U.S. Department of Homeland Security has a faith-based security and communications advisory committee. The list is long, from environmental policy to development to counterterrorism, from constitution writing to nation building. Religious outreach is celebrated today as the solution to the dilemmas posed by modern governance. In this new era of partnerships, state and religious authorities are celebrated as they work together to advance shared interests, promote tolerant religion, and, we are told, redress the strategic errors made by ignoring religion, which is often described as a missing dimension of statecraft. My question in the face of this onslaught is, what does it mean for the governance of pluralistic societies when governments, like the United States, but others too, divide the world up into believers and non-believers, into religions and not religions, and then pursue various political objectives? I'm interested in the politics of these programs. To understand these politics, we need to situate them on a longer historical timeline and as part of a much bigger American project. It goes beyond secularism and beyond the First Amendment. And I will be very brief in summarizing my findings here. But at least since the Second World War, the US government has understood the promotion of free religion overseas to be something that benefits the rest of the world. It is saving the world's peoples from religious and political tyranny. US-sponsored religious freedom programming and religious engagement has been designed to instruct individuals and groups overseas on how to be free or freer versions of themselves. While many of these activities would indeed raise constitutional eyebrows if pursued here in the United States, they are fully legitimate as foreign policy priorities due to what is sometimes called the national security exception, but also, and I want to suggest very importantly, due to a powerful myth of American exceptionalism. According to this myth, the United States invented religious freedom. It is the place where, in fact, religion and freedom have been perfected. The United States is where religion goes to become free. Today's religious engagement programming is simply the latest iteration or stage or step in a long history of attempts to position the U.S. as the global guardian of free religion and of freedom in general. These programs operate on the assumption that the U.S. is the leader of the free world and the world's greatest champion of free religion. This view dominates foreign policy circles, and in it, what is called religious freedom is achieved through the cultivation and the establishment, and I use that word intentionally, of forms of religion that conform to American standards of what it means to be free religiously and free politically. These standards are, of course, not universal, needless to say. They have a history. So while religious engagement does attempt to politically strengthen U.S.-friendly religious authorities abroad, it is at the same time, and more fundamentally, a project of religious reform. This is why talking about secularism doesn't help us. It is a project of transforming religions into what is understood by the state in a particular time and place into better versions of themselves. Now, these projects cannot be captured, I'm suggesting, under the terms of establishment, disestablishment, secularism, freedom, or unfreedom, which orient many and most legal assessments of their constitutionality in the U.S. case. It's a different story operating abroad. The debate over the First Amendment then captures only a small fragment of a much larger story about American power, history, identity, and religious history as well. The book illustrates this argument, or draws it out basically through 3 examples taken from the history of U.S. foreign relations. I'll just tell you what they are, but I won't give you any details about them for reasons of time. The first example is U.S. efforts to promote what was known as global spiritual health during the Cold War. That's not my term, that's the term that was used at the time. A critical element in anti-communist propaganda, many Americans viewed the promotion of spiritual health as an obligation owed by a privileged subset of the world's populations to citizens abroad who were at risk of falling prey to communism. As an early example of government-sponsored religious engagement, this religious offensive, as it was called at the time, involved U.S.-sponsored efforts to foil communist designs through religious reform both at home and overseas. During the 1950s, the U.S., for example, established alliances with anti-communist religious leaders throughout Southeast Asia to promote forms of Buddhism that conform to American conceptions of political and religious freedom. The U.S. sent a Buddhist advisor to Cambodia and cultivated a religious alliance with a Thai police general who founded the Society for the Promotion of Buddhism in 1954. 2 years later, in 1956, the Operations Coordinating Board, a U.S. government agency reporting to the NSC, formed what was called the Committee on Buddhism to coordinate this religious offensive. It was made up of representatives from the State Department, CIA, USIE, and other agencies, and this Committee on Buddhism was charged with studying the effectiveness of Buddhist organizations in Southeast Asian countries to discover, quote, ways and means to ensure that the influence of Buddhist monks and lay leaders is exerted in favor of U.S. interests, end quote. What I'm suggesting then is that today's religious outreach efforts, like those of the early Cold War, are also at the core of the American government's political attempt to break off those defined as U.S.-friendly moderates from U.S. hostile extremists. Taking a longer-range perspective on these activities challenges the assumption that religion has been simply absent from foreign policy until recently due to a deeply institutionalized allergy to religion in the form of some kind of anti-religious variety of secularism. This is a myth. To the contrary, even a very brief excursion into American history suggests that U.S. foreign relations are replete with attempts to cultivate forms of religiosity that not only align with American strategic interests, but also conform to specific conceptions of what it means to be religious and what it means to be free. These efforts, of course, continued in new forms after the Cold War was over. Similar objectives motivated another example from my book, a U.S. Agency for International Development Programs attempt to promote religious tolerance in Albania in the early 2000s. There are millions of these programs. You probably know them as well as I do. I'm not going to go into them in great detail, but like the Cold War campaign for what was called spiritual health, the USAID project sought to transform Albanian religions and religious subjects into, again, freer and more tolerant versions of themselves to make them allegedly less susceptible to extremism. More recently, and in a third example from a different realm of U.S. practice abroad, the U.S. has pursued overseas religious reform through the expanded duties of U.S. military chaplains. Military chaplains who are stationed abroad have a new set of duties. Since 2009, their responsibilities have now grown to include religious outreach and liaison activities in local communities abroad. So chaplains are required to serve as cultural consultants and as sources of what the U.S. Army calls human terrain intelligence, as well as liaisons with local religious leaders. In addition, this is of course on top of their regular job, which was to meet the religious needs of service members and their families stationed abroad. So, each of these religious engagement activities are understood in First Amendment terms to secure the possibility of the free exercise of religion at home and abroad, not to promote its establishment. But I'm suggesting that the story just doesn't end there. And to see the bigger picture and what's actually going on, we have to reach for a vantage point beyond the legal debates over the First Amendment. We have to think more comprehensively about U.S. political, religious, and global history, all at the same time. In recent years, the extraterritorial application of the First Amendment and the extent to which particular U.S. activities abroad should be considered secular or religious have been subject to much legal scrutiny, bureaucratic hand-wringing, and anxious political debate. As an example, the report published by the Chicago Council on Global Affairs Task Force on Religion and the Making of U.S. Foreign Policy a few years ago suggested that legal confusion about these activities, are they constitutional or not, was undermining the effectiveness of U.S. foreign policy by hindering the government's ability to engage with religious communities. The report then criticized the Justice Department's Office of Legal Counsel for failing to provide legal clarity, calling on the government to resolve this uncertainty about the extent to which the Establishment Clause actually applies to U.S. actions overseas. The authors of the report remain divided as to whether the constitutional provisions of the religion clauses apply or not abroad. People don't know. The debate goes on. Is it constitutional or not? Are these activities religious or secular? Everyone gets dizzy running in circles, chasing their tail, trying to figure this out. And the legal scholars continue to publish reams. But my question is this really the issue at all? And I think it's not. So there's a crazy quilt of regulations and restrictions that govern U.S. activities abroad. The military has more leeway than anyone else. I already mentioned the national security exception. To give you a quick example, during the occupation of Iraq, an American Army colonel applied for funding from the Commander's Emergency Response Program, CERP, to rebuild a mosque. The mosque had an imam who was wavering between working with the Americans or joining the insurgency. CERP rejected the colonel's request to rebuild the mosque, and so the colonel changed the word mosque to cultural site and resubmitted the application. The funding was approved and the mosque was built. At USAID, contractors are required to show that their activities are, quote, not inherently religious and promote a secular purpose. But by and large, it's completely unclear to the extent to which the clauses apply to U.S. actions abroad. The Supreme Court has never ruled on the matter. The few lower court opinions are narrow and inconclusive. I'm not going to be able to review those here, but the big one, Lamont v. Woods, the Second Circuit held that the Establishment Clause did apply abroad, but then said that the standard of analysis differs for foreign affairs and proposed a balancing test, saying, well, when American funds are going to sectarian foreign organizations, the government should have an opportunity to demonstrate a compelling reason why a usually unacceptable risk should, in this case, be borne. Lamont was then superseded a few years ago in 2007 by Hine, the Hine case, Hine versus Freedom from Religion Foundation, when a group of U.S. taxpayers, many of you will recall, brought an Establishment Clause challenge to the constitutionality of the White House Office of Faith-Based and Community Initiatives that I mentioned earlier, and specifically the use of that office to convene conferences of religious groups. So the plaintiffs said that the meetings were favoring religion over non-religion and therefore were a form of establishment. The Supreme Court ruled in Hine that because no legislative body had directly authorized that funding, taxpayers didn't have standing to bring suit in federal court. And so as long as the government's not funding worship, as long as there's no coercive government proselytizing that harms an actual person, the government can essentially now promote and fund religion as it chooses. This is a form of establishment, and I think we need to switch our analytic and think in those terms. It helps us to see this. As Sullivan has glossed the Hine decision in particular, she says the president can promote religion just as he can promote any other social policy, limited only by electoral politics. Austin Dacey, writing in Religion Dispatches, took it even further and said, even if the State Department's new engagement policies resulted in direct funding to religious organizations, they might nevertheless be immune from constitutional challenge. So it would appear that the clauses are in some important sense irrelevant to the case at hand. And I think in the US, it would appear that the debate over religious engagement is not really about whether religion can be separate from government, whether it can be ignored or contained, as many separationists would have it, and as many would understand the terms of American secularism. Rather, the notion of separation has itself broken down as a useful description of the relationship between religion, law, and public policy as it's actually lived, and I think this meeting attests to that. There is no religion anywhere without government involvement in some form. Religion never left public life. Rather, it has assumed different forms and occupied different spaces under different regimes of governance, many of which we call secular. The debate over religious engagement is also, however, not about whether persons of faith should be included in public life. Of course they should. And who decides who is a person of faith today and who isn't? I was thinking this morning when Brian Grimm was up here presenting his numbers on peoples of faith. It's very unclear to me how these lines are drawn and by whom. I think the question we need to ask is, how do these entanglements between governments and individuals and institutions take shape? Who gets chosen and why for engagement? How are they identified and by whom? Which versions of which religion are supported? Which religious authorities are privileged? And who exactly are they understood to be representing? Religious outreach enacts some form of establishment. It requires that governments decide which groups count as religions in the first place, and then that they choose among different sects and denominations, inevitably privileging some at the expense of others. As you all know, there's rarely full agreement inside any tradition on who speaks for a tradition, which leader is definitively in or out of favor, which texts or practices represent the core of that tradition, which are orthodox or not. The pretense that it is possible to engage all religions neutrally on equal footing masks the politics of religious engagement. It is, in fact, always easier for the religion of the majority, going back to the question of the young lady earlier this morning, the religion of those in power, the religion of the particular version of a religion supported by the US, the UN, the Chinese government, corporate interests, the European Union, or anybody else, to carry more weight politically than others. Groups that are disfavored are then likely to be classified as cults or extremists, and sympathetic groups are registered and protected as tolerant and orthodox. And here I will give you a quote directly from the words of the U.S. Ambassador at Large for International Religious Freedom, now our former ambassador, Suzanne Johnson Cook, and she said quite simply, there are certain areas where the U.S. government has muscle, and we can also promote religious leaders, end quote. So I'm going to wind down here. When the U.S. engages religions abroad, the point is that groups that look like a religion to Americans get more attention. Dissenters and doubters fade into the margins. Non-traditional religions are met with skepticism and puzzlement. On a landscape defined by religious engagement, the U.S. and other power brokers become the arbiters of what and who counts in the construction of human activity as religious, and which versions of which religions count most. This cannot be overcome by simply increasing the number or diversity of religions engaged. The commitment to religious engagement also gives an edge to religions that conform to an American understanding of what it means for religion to be free. While some religions are naturally seen as free of the need for regulation, others are not so free, and intervention is required. And I'll wrap up with a quick example. During the U.S. occupation of Afghanistan, American soldiers built madrasas in Khost, a province on the border with Pakistan. Commander David Adams, the head of the U.S. Provincial Reconstruction Team, said, quote, this was in an interview with the Financial Times, "We would like to see small religious schools in every district so that parents don't have to send their children over the border into Pakistan," end quote. Any attempt to situate this project in a First Amendment context would hit a wall. As one analysis which attempted to do so concluded, it is not clear what official overall legal guidance enabled the U.S. to build those schools, or if the national security justification was invoked. These schools were built with little fanfare in the press, positive or negative, nor did they engender any public discussion at all as to whether this violated the First Amendment. The soldiers just built the schools. The soldiers built the schools to ensure that Afghan children would have the opportunity to be properly religious, pro-American, and free, which in this case, and so many others, are understood as indistinguishable. The question of whether these activities are constitutional is, in some important sense, beside the point. International public policy needs to be informed by a sophisticated understanding of religion. But when governments engage individuals and groups as religious groups, they are forced to discriminate. Who is chosen and which orthodoxies are enshrined as voices of authority? To rely on religion as a category in law and foreign policy is always in some form to establish it. Thank you.
Good afternoon, everybody. Bonjour, tout le monde. To begin, I would like to thank Professor Durham for having invited me and for giving me this opportunity to speak to you. I will speak not about French secularity. A 2-day conference at least would be necessary, but only about one aspect, more specific topic, religion in education in France, a challenge for the secular state. The relationship between the school system and religion in France has been a very sensitive topic in the country's history. The Republican state and the Catholic Church were fiercely opposed, with priests and teachers arguing over their influence on children's education. Most importantly, with the laws that secularized the education system between 1882 and 1886, the separation of the church and the school system in France preceded that of church and state, according to the law of 1905. Since then, the state school system has not been concerned with religious education, whose responsibilities has fallen on the families and religious institutions. For this reason, a day off school during the week was allowed, initially on Thursdays and on Wednesday. I quote, "Primary state schools have one day off on the week in addition to Sunday in order to give parents the opportunity to make arrangements, if they so wish, for the religious education of their children outside the school." End of quote. In school, moral and religious education was replaced by moral and civic education. As much out of fear of conflict and respect of the student conscience, there was a tendency to avoid the issue of religion in the classroom. But quite apart from the secular state school system as a national institution for teaching the values of the Republic, and despite the struggles against congregational schools, private schools education, mainly Catholic, was maintained. The conflict between state and private school, typically called the school war, resurfaced at the end of the 20th century with massive demonstrations in favor of private school in 1984 and in favor of state school in 1994, whenever there were plans to modify the status quo in one way or another. Today, three major contemporary developments have left their mark on the relationship between religion and the school system in France. First, the integration of private school, mostly Catholic, in the public service of national education through contracts of association in accordance with the law of 1959. These agreements guarantee the recognition of the specific character and ensure the state financing of the schools, but in return, private schools had to accept all students and follow the state curriculum. Secondly, the decision to develop the teaching of religious facts, religious phenomena, religious issues, faits religieux in French, in the secular school system, according to the Régis Debray report of 2002. In order to contribute to the students' knowledge of civilizations and present and past evolutions. Thirdly, the concern to protect the principle of school secularity, laïcité scolaire, by restricting the students' expressions of religious identity. The law of 2004 banned the wearing of symbols, including a cross, a yarmulke, or a veil that ostensibly manifest a religious affiliation in school. But discrete symbols were permitted. Thus, the French secularity, in principle, is neither an agnostic counterculture nor the implantation of a total privatization of religion, but rather a measure for social pacification, allowing the regulation of religious diversity in society, while at the same time guaranteeing the religious neutrality of the state. But in reality, things are not always not so simple, and the French way of managing religion is often marked by a deep distrust of state power towards religions and the threat that it can entail over individual freedom and the emancipation of the spirit. The evolution in the last decades, the emphasis was put on the necessity to reinforce the common education for all students and to reinforce this common education in two directions: common moral teaching and teaching about religion. In a document entitled The Common Foundation of Knowledge and Skills, defines everything that is essential to master at the end of compulsory education. And the common foundation, which is represented as the cement bonding the nation, is comprised of a set of essential knowledge and skills. There are 7 skills areas, but among the 7 skill areas, we can see knowledge of humanistic culture. And the 6th is social and civic skills. Through humanistic culture, the forming of judgment, taste, and sensitivity is targeted, as is reflection about one's opinions and feelings. In this perspective, it seems essential to have historical and geographical reference points in order, I quote, to share a European culture. According to this official document, this involves, I quote, the knowledge of key texts from antiquity, the Iliad and the Odyssey, accounts of the foundation of Rome, and the Bible. An introduction, I quote, the diversity of civilizations, societies, and religions, and to religion in France, in Europe, and in the world by relying on seminal texts, in particular, excerpts from the Bible and the Quran, in a general spirit of secularity that is respectful of conscience and beliefs. Through this text, we can say that teaching religious facts is a key part of the educational objectives of school education. More recently, in 2012, our Minister of National Education wanted to strengthen the teaching in school of a common moral education that will contribute to the development of respect, peaceful coexistence, and freedom. End of quote. To this end, he commissioned a report on teaching secular ethics, which was prepared in 2013. This report initiated a debate on the general outline of this common ethics in the context of a social situation that is characterized not only by a plurality of religious and philosophical sensibilities, but also by a plurality of conception of a good life, namely a true normative pluralism. But the emphasis was particularly put on teaching about religions in public school. Since the end of the 1980s, various voices have brought back to the question of religion in school. Did the secular nature of the school system not definitely settle this issue by giving back to families the freedom of choice about religions and ensure the independence of the school institution and its teacher as regards any religious authorities? In many respects, yes. But the question of religion in school emerged in very different circumstances compared to the period when the principle of secularity became institutionalized. It did not emerge against secularity, but within secularity itself and besides. It constituted a tangible expression of the success of the principle of secularity itself. It was not a question of all the consequences of the fact that, I quote, a knowledge of religious cultures is necessary for the understanding of our societies, their past and their present state, their literary and artistic heritage, and their legal and political system. And the debate in the French society, a political and social debate. How and why? In view of what and for whom can school, if we consider that it must undertake this task, take into account religious cultures? There was a topic of debate where various expectations concerning school and religions were combined. Although this debate did not lead to the creation of classes on the history of religions provided by a specific group of teachers, the fact remains that in France, a new insistence on religions has emerged in the history and humanities curricula since 1996. By putting Régis Debray report, Régis Debray, an atheist philosopher, agnostic philosopher, by putting Régis Debray report in charge of a working group dealing with education on religion in a secular school system in December 2001, the Minister of National Education, Jack Lang in this time, acknowledged that, I quote, if a school that is truly and serenely secular was to give each student the opportunity to gain an understanding of the world, this means that teachers should take into account religions as influential elements and to a large extent as structuring the history and mankind, sometimes as peace and modernity factors, sometimes as factors of discord, deadly conflicts, and regression. It was after 9/11 that the Minister Jack Lang felt the urgent need to undertake an initiative to reinforce the broaching of religion in school. Hence, there was an urgent need to make a transition, as Régis Debray very clearly stated, from a secularity of incompetence, laïcité d'incompétence. According to the secularity of incompetence, religion by nature does not concern us. But the necessity to move from a secularity of incompetence to a secularity of understanding, une laïcité d'intelligence. And according to the secularity of understanding, it is our duty to understand religion, to know and to understand religion. To do this, the Debray report proposed a number of measures concerning the curriculum and the initial and continuing training of secondary school teachers. In this perspective, three great themes involved in teaching religions were identified. We can characterize these three themes as follows. First, education is a language of symbolism. Teaching about religion amounts to recognizing the specific language that gives one the opportunity to name and decipher symbols, essentially to understand one way of explaining the world. Specific language. Secondly, a contribution to the knowledge and understanding of our cultural heritage. Teaching about religions gives young people the opportunity to gain knowledge of the endless number of masterpieces in our human heritage. And third, a contribution to citizenship education. Finally, teaching about religion consists of making students capable of understanding different religions and the role of religions in the contemporary world. But in France, as a historical heritage in the in France, there has been a tendency to reduce religion to a private and personal opinion. According to Article 10 in the Declaration of 1789, no one shall be disquieted on account of his opinions, including his religious views, provided their manifestation does not disturb the state order established by law. End of quote. That a tendency to reduce religion to a private and personal opinion, thus forgetting that religion is a question, on the one hand, of deep convictions that strongly motivate people who believe in them, and in the other hand, of collectively organized convictions that are expressed in a whole range of visible manifestations, monuments, gatherings, gestures, and so on. Religious phenomena exist because there are men and women who experience religions, individuals. There are religious organizations and institutions. There are religious works and written, pictorial and architectural traces. In short, text and ritual, representation and attitudes, writing and codes of behavior. If state school does not know if God exists, it does and should know that there are individuals and groups who believe that God exists. And thus this fact has all kinds of impacts on personal and social life. The option selected in the Debré report was thus to use text and writings that illustrate religion as a point of departure from which to trace their meaning. Thus, as in other European countries, France faces a new social and religious reality characterized by an increasing religious and philosophical diversity, especially an increasing number of people who state that they have no religion, and students that have no religious knowledge and no familiarity with the subject of religion. Additionally, there are a large number of Muslim minorities in France today, a very pronounced religious pluralization in this society as in other European societies, and different types of groups and networks with different religiosities, concern about the sectarian drifts among such groups and current international affairs that illustrate the intersections between religion and politics in various conflicts, anti-Semitism, Islamophobia, and the question of limiting religious expression in school. This is an opportunity to reflect on the question of how school deals with, treats, and teaches religious facts. Faced by these challenges, it is necessary not only to understand each other and to coexist peacefully, it is necessary to integrate. It is the aim in this choice made in France, to integrate teaching religious issues, teaching religious facts, into the objectives of school and its specific educational mission, namely to respect the prevalent ethical and pedagogical principles in different educational fields, to respect the increasing religious and philosophical plurality found in class. This reinforces the preference that may be granted to a social and historical objectivation of religions that gives the opportunity to take a certain distance and respect the students' freedom of conscience. Teacher training is a key challenge, since teacher training is currently inadequate and a great deal of effort has to be made for teachers to be able to teach religious facts with calm assurance in terms of not only required knowledge, but also of approaches and principles. Learning a social historical approach with its critical dimension of studies of sources, interpretations, transmission, and evolutions. Such learning, when applied to religious facts, is in itself, according to me, an important contribution to citizenship. Why? Because it places religious phenomena in the space of collective deliberation, considers them outside their individual and collective religious appropriations. In other words, and even if it involves one's one religion, it means learning to speak as if it were someone else's religion. The simple fact of having to talk about religions in front of a diverse audience, of not being able to rely on the collusion between co-religionists, but of having to objectivize and make explicit the world of representation and attitudes that correspond to a religion in a position that includes religious facts in the citizenship of pluralist democracies. It recognizes from the outset that the religious world under discussion is not an all-encompassing symbolic structure for all of society. That is, even in the majority, only one orientation among others. This does not prevent us, when teaching religious facts, from reserving a specific place for the most representative religions in the country, in the sense that these religions have left their mark on the history, the culture, and the tradition of the country in which this type of education is received. Thus, teaching religious facts in this perspective can also contribute to citizenship in that it is a part of a national education. It is about a state school, education in state school in a given place and with a given historical, cultural identity. Thank you very much.
Good afternoon, everyone. Is this working? It doesn't sound like it is. I don't think so. I don't know. Can you hear me well enough? Now it is. Huh? I think so. Good afternoon. It's a pleasure to be here with you, to see some familiar faces, to make some new friends. Thank you, Cole, for the invitation. This title, I know it doesn't seem to speak directly to the topic at hand, Varieties of Secularism, but here's the link. First, the thoughts that I will share with you today are based upon research that I've conducted with religious minority groups in majority Orthodox countries, 4 countries in particular: Greece, Romania, Bulgaria, and Russia. Orthodox countries, this is the second point, Orthodox countries are the focus of extensive scholarly discussions about whether orthodoxy is a delimiter of a particular variety of secularism. And I should pause here to say that whenever I say orthodoxy from here on out, I mean it with a capital O. Orthodoxy is in Eastern Orthodox Christianity. And third, central to discussions about orthodoxy representing a different variety of secularism is the relationship between religion and national identity that we tend to find in majority Orthodox context, and specifically the way close links between religion and national identity underpin close church-state relations. So I hope that doesn't sound all too tentatively linked to our session topic, but I think this is a subject that is pertinent for an audience interested in intersections between law and religion, because the relationship between religion and national identity is among several factors making the legal protection of religious freedom particularly challenging. In the extent to which a close religion-national identity link leads to exclusions at various levels of religious minorities, and I say in the extent to which, I'm not assuming that's always the case, but in the extent to which it is, it represents a conundrum for those striving towards religious pluralism. Okay, sorry. It represents a conundrum for several reasons, one of which is that it is often banally manifested. A close relationship between religion and national identity is manifested in all kinds of symbols around us, including flags, anthems, depictions on currency, etc., much like Michael Billig's description of banal nationalism. That's the title of a 1995 book of his on nationalism. A religion-national identity link underlies a number of invisible national norms. Take, for example, the Swedish case of the taken-for-grantedness of using church buildings for public school functions and ceremonies. The question is, where do banal manifestations of majority religion stop being banal and actually impinge upon freedoms of religious minority or non-religious groups? As Billig notes, banal does not simply imply benign. A lot more than we may realize may fall within a gray area between the benign and the pernicious. A second reason the religion-national identity link represents a conundrum is that if and where it is found to be pernicious, you can't exactly put it on trial. Thinking about the European legal context in particular, European institutions go to great lengths to assure Europeans that European unification does not require, but in fact, or in theory at least, discourages cultural leveling. Unity in diversity is an EU motto, and protection of diverse national identities is part of its claimed aim. The European Court of Human Rights, itself not an EU institution, but still an integral part of the European unification project, also embraces this aim through the principles of subsidiarity and the margin of appreciation that it is allowed to individual states regarding nationally sensitive issues, as is, for example, the relationship between religion and national identity, and the associated church-state relations. These are areas that the court has been generally pretty careful with, and increasingly so, we'll see. Third, it's difficult to change the relationship of majority religions to national identities is often deeply embedded in the national narrative and especially in the education system. It is also often enacted by nationalist forces, whether on the part of the church or on the part of the state. People mobilize around religion-national identity links. We see this conspicuously in majority Orthodox cases, but not only. And also fourth, who, if anyone, has the authority to try to change it? Is that a legitimate aim? All of the above are interesting normative questions, and there's a great deal of excellent scholarship, much of it by people in this room, arguing in divergent directions. This scholarship frames a fascinating debate about the proper place of majority religion in the public sphere. Today, I don't want so much to add my own voice to this very well-developed discussion, but rather to inject my interviewees' voices from the research that I mentioned. And I want to inject their voices into this discussion to explore how, why, and under what conditions does the relationship between religion and national identity become problematic. In Slavica's words this morning, best to look at these things from the ground up, and so that's the idea behind this research, see what's happening on the ground. After sharing these voices with you, I will consider the notion of what, if anything, can be done about the problems that arise from this relationship. So I'll say a bit about my research. My research design, here's the topic of that particular project. It took place between 2010 and 2013. So the research design was built around two questions. What are the experiences of religious minorities in the country context of Greece, Bulgaria, Romania, and Russia? Sure. No worries. Okay. And second, what are the factors and mechanisms influencing limitations to religious freedom where they're experienced? The country case study selection includes old and new and non-members of the EU. Greece joined in '81, Bulgaria and Romania in 2007, and Russia remains not a member of the EU. And countries with and without an experience of communist regimes. Together, the countries cover a range of levels of religiosity versus secularity, from highly secular in the Bulgarian case and highly religious in the Romanian case. My empirical research was qualitative in nature. It was aimed at understanding the attitudes and practices of the religious majority vis-a-vis religious minorities, and the experience of religious minority groups within this context. The fieldwork I will reference consists of in-depth, semi-structured interviews with this group of people, representatives of religious minority groups, representatives of the Orthodox Church, representatives of state organs dealing with religious affairs. Often there was a Ministry of Religious Affairs or something of the sort, and representatives of NGOs dealing with religious freedoms issues, and finally lawyers handling religious freedoms cases. When I say the NGOs and the lawyers, they were also often handling and representing secular and secularist organizations. Besides offering a vibrant picture of current grassroots developments in the domain of religious pluralism, in-depth interviews offered insight into the deeper mentalities, perceptions, and perspectives of people in positions of power, and to their broader objectives. What do they aim to achieve? That's something I want to look at. These perspectives, mentalities, etc., have value independent of the actual facts and realities on the ground. They offer, altogether, a picture of pluralism, or lack thereof, internalized by the representatives of various stakeholder groups. I'll now draw from that interview material different perspectives on the religion-national identity link as either banal, benign, or pernicious, and I will draw from different voices from each category of interviewees. The examples I offer are only indicative and they're necessarily selective. Obviously, I can't take the time to go through all of the material that's relevant to this topic, but as will become clear eventually through these examples, the boundaries between the three categories are somewhat fuzzy. Here, banal. I start with a quote from a lay representative of the Bulgarian, I think. Yeah, the Bulgarian Orthodox Church. The PM in that quote is the Prime Minister. So she's describing the public presence of Orthodox clergy, which is something that's very common in these majority Orthodox contexts, more so in the other cases actually than in Bulgaria. And she's describing this as something that is, you know, the norm and what's wrong with it, and it's just, it's very common, it's natural, it's fine. That's the perspective that she's communicating. Another banal manifestation of religion and national identity link is the religious field on the Greek national identity card. Now this is old news in a sense because it was removed from the national identity cards in Greece in 2000, but only after a very intense church-state debate over this issue. And it still remains a really bitter point for some representatives of the Greek Orthodox Church. So this is listed as another expression of, you know, so what's wrong with it? It was fine, what's the harm? It expresses the religious identities of those who have religious identities, and, you know, then again, seen as something banal. Another example, symbolic references to the Orthodox Church or to orthodoxy in constitutions and legal texts. Many interviewees present this as something that is, you know, just in the background. It doesn't make much of a difference because these, well, I'll read the particular references in a minute, but what do I do now? I don't even know. Sorry, it happened before too. Oh.
It's probably here.
No, no worries. I think you have to do
Is that, oh,
this is,
yeah, that's where we are.
Yep, okay. So back to the symbolic references. So for some interviewees, these two are banal, that in theory they're purely symbolic, references to the Orthodox Church and in their particular formal text. So in the Bulgarian case, in the Bulgarian constitution, it defines the Christian Orthodox religion as the quote-unquote traditional religion of the Republic of Bulgaria. In the Romanian case, the 2006 law on religion states that the Romanian state recognizes the important role of the Romanian Orthodox Church and that of other churches and denominations as recognized by the national history of Romania and the life of the Romanian society. In the Russian case, the preamble to the 1997 law on freedom of conscience and religious associations recognizes Orthodox Christianity's quote-unquote special role in Russia's history, spirituality, and culture, and proclaims respect for Christianity, Islam, Buddhism, Judaism, and other religions constituting an integral part of the historical heritage of Russia's people. But always you see a special place for Orthodoxy here. By contrast, in the Greek case, there's no claim to any kind of symbolism behind it. It's very clear in Article 3 of the Constitution. It states that Orthodoxy is the prevailing faith. There's just a lot of debate as to whether that notion is prescriptive or descriptive. Is it meant to say that it should be, it always will be the prevailing faith, or just descriptive of a reality of a majority faith? Benign, examples of benign. Here we have a Bulgarian government official explaining that national religion is necessary and is a positive unifier for society in the context of the political and social chaos in the post-communist context. This is a perspective that I came across a lot. It's a good thing for this reason. It's a fair recognition of the important historic role of the Orthodox Church in exchange for historical wrongs. I have a quote here from a Romanian government, Romanian government official who's responsible for religious affairs. And here's his understanding of, it's a fair exchange. The church was wronged tremendously in the past, and so the state owes the church, and it owes also in a financial way that is, and from this quote, eternal, basically. Another example, a Greek Orthodox priest talking about religious education and just saying that we must teach our children Christian morals. So for many, the teaching of religious education in public schools is also an expression of the benign way that religion and national identity are linked. This leads us to the pernicious category, because of course one's person benign can be another's pernicious. And religious education is a conspicuous problem area for many religious minorities, globally, but certainly in many majority Orthodox contexts. There is mandatory Orthodox religious tuition in Greek schools, with exemption offered only to people who formally request exemption on the basis of religious difference, and so they have to make a formal announcement of a different religious minority affiliation, which would then appear on the school diploma, and which of course in turn entails a breach of private data protection. So this is an example of the interconnectivity of problems, how one problem may lead to a different type of problem. Limited access to cemeteries. This reinforces the point above about the interconnectivity of problems. In several cases, governmental justification for the lack of public cemeteries and for the fact that most cemeteries after the collapse of communism were given to the Orthodox Church was in part to make up for the past wrongs of the state against the Church, which is point 3 under the benign category before. But as a result of this seemingly for some benign righting of wrongs, many religious minority groups have suffered difficulties burying their dead in these cemeteries and or holding funerals there. Another example, so before I was talking about the public presence of the Orthodox clergy, but here recall that in the benign category I had listed the public presence. Many interviewees feel that this public presence cannot but have a less transparent side to it, whereby the church influences state decisions in ways that are detrimental for the non-Orthodox. Here I have a couple of quotes. Was it 3? 3 quotes to share with you. They're all from the Greek context. The first 2 from people working in the Ombudsman's office, and the third from an NGO representative. The first suggests that there is a message communicated by the public presence of the clergy which influences how others in society act. The other 2 quotes suggest that the public presence has a behind-the-scenes element of political influence of the church. The identity cards reference here has to do with the fact that the government won the battle in a sense because they did manage to remove the reference to religion from the national identity cards, but they lost the war and that they lost the next elections in a very bad way. So the government really received a strong warning, the state in general, all politicians, that you don't want to mess with the church. I feel like I'm going backwards, am I? Okay. So the last category here under pernicious is the real effects of the quote-unquote symbolic clauses. My research points to a large gray area between religion and law in terms of interpretation of the precepts and the extent to which supposedly symbolic references in legal and constitutional texts influence, so the extent to which that influence remains truly at the symbolic level. Here I also have multiple quotes. Oh, that's not where I want to go. There. Both from the Russian context. The first is from a Russian parliamentarian who handles religious issues, who says, the very, I'd say, controversial thing, but in practice, practice is practice, and that's another issue. And then the second is from a representative of the Ombudsman's office. And this was something that I think is more obvious in the Russian case than in the others, that there was the formality of the law and then what's happening in practice is a completely different issue. So many religious minority groups were bothered by such clauses. No, I really didn't do anything there. Is it meant to be this dark? I can't read. I can't see my text, it's tiny as it is. Okay, thank you. So I was saying, many religious minority groups were bothered by such clauses. Most conspicuously, their complaints operated at that end of the spectrum of religious freedom where people call for equality and non-discrimination. In other words, why should one religious group be singled out? It's unfair. But less conspicuously, there were instances of direct citations of these clauses as reasons behind limitations experienced by religious minority groups, notably even by some governmental officials. So again, it's easy to see from these examples that the lines between the banal, the benign, and the pernicious are blurred in terms of the effect, but not in terms of the perspectives of the actors in question. And this distinction is key. On to the second question that I posed at the outset. What, if anything, can be done about the problems that arise, if and when they do, around close religion-national identity links? As I mentioned before, scholars are really divided on this issue, and they disagree about the boundaries between the banal, the benign, and the pernicious. Some argue that strict separation of church and state is the solution. Others argue that we need to go further and have absolutely no privileging of one or more religions by the state. And in the context of these kinds of normative disagreements, what can law do to help? Let me just use some illustrations of limitations of the capacity of law to redress such problems. Here I'll broaden my focus away from strictly majority Orthodox cases, both because some of the problems I'm addressing are of a more general nature and applicable well beyond majority Orthodox contexts, but also because until now my examples have been about freedom of religion, but now I want to turn my attention to examples of freedom from religion. Two particular provocatively titled book publications can serve usefully as a frame for our discussion here. The Tragedy of Religious Freedom by Mark de Girolami in 2013, and The Impossibility of Religious Freedom by Winfred Fowler Sullivan in 2005. The concerns and discussions of these authors are distinct, but both speak in terms of predicaments. De Girolami addresses the predicament of legal theory, and Sullivan the predicament of religion. Legal theory, according to de Girolami, seeks, I'm quoting here, seeks to fix crystalline conceptual categories, but the social practice of religious liberty is resistant to legal theory's self-assured, single-minded drive to evaluate, justify, and adjudge. For her part, Sullivan argues that religion fits, I'm quoting again, fits uneasily into a legal scheme that demands such categories and such expert certainty. Rationalizing religion in the ways proposed by courts and legislatures fails, she says, to capture the nature of people's religious lives at the beginning of the 21st century, or maybe of any century. In short, the predicaments that they describe have a common basis in the messiness of lived religion. One of the messy realities with which courts and governments are called to deal with, whether openly or not, is the relationship between religion and national identity. The religion-national identity link has been on trial many times in both the US and European context. I'll illustrate with references to two cases only: the case of the Pledge of Allegiance in the US context and the case of the crucifix in Italian public schools in the European context. Especially notable are the intricacies of the cases and the incredible difficulty, or impossibility, as Sullivan might say, in untangling religion, culture, history, and identity just enough to be able to ascertain whether religious freedom has been violated. Here is a slide with the Pledge of Allegiance, because you may not all know it. The American Pledge of Allegiance has made its way into court several times in US history, particularly since the addition of the words "under God" in 1954. The first time it reached the Supreme Court was in 1943, just 1 year after the pledge was formally recognized by the US government, and that's the same time when it entered public schools to be recited by the pupils. In that 1943 case, the mandatory reciting of the pledge in schools was challenged by a Jehovah's Witness, who refused to recite it on the grounds that it was against his or her religious beliefs. Here, the Supreme Court ruled that requiring a person to say the pledge entails a violation of the First and 14th Amendments. Again, the words "under God" were added to the pledge over 10 years later, in 1954, and they were added at the request of President Dwight D. Eisenhower to Congress, notably in the Cold War context. In the early part of the Cold War context. The next time the pledge reached the Supreme Court was in 2004, and then it was specifically for the words "under God." Here, Michael Newdell, the father of a schoolgirl, argued that the teacher-led recitation of the pledge in public schools constitute religious indoctrination, and thus violates the establishment and free exercise clauses of the First Amendment to the US Constitution. The case was dismissed on the technicality that Newdell lacked legal standing to bring the case because he was a non-custodial parent. The case hasn't since reached the Supreme Court again, but it remains an open issue in a sense. It's returned to courts at the national level, at the state level, nearly 10 times since that 2004 Supreme Court case. I think most recently in May in Massachusetts. The case of the Pledge of Allegiance, in its multiple forms and at its various levels of judicial politics, is very much about the relationship between religion and national identity. It puts American civil religion on trial, since the pledge is one of the key rituals of American civil religion. Turning to the European context, in the Hautes versus Italy case before the European Court of Human Rights, the mother of 2 children attending Italian public schools argued that the presence of the crucifix in the school classrooms violated her right to educate her children in accordance with her own religious or philosophical beliefs. This is a right enshrined in the European Convention of Human Rights, which is protected by the European Court of Human Rights. In November of 2009, the court ruled unanimously in Lausie's favor. The Italian state then sought and won referral of the case to the Grand Chamber of the European Court of Human Rights. As in the cases around the Pledge of Allegiance, in the Hautes versus Italy case, the relationship between Roman Catholicism and Italian national identity complicated the case. In its dismissal of Lausie's plea in 2005, the Italian Administrative Court argued that the crucifix was a, I'm quoting here, historical and cultural symbol, thus possessing an identity-linked value for the Italian people in that it represents the historical and cultural development characteristic of Italy. Through both these cases, we observe a process through which Christianity variably ceases to be religion and becomes cultural identity. The examples of the Pledge of Allegiance and the Lautsi case serve as fruitful ground through which we can explore a further complication of the relationship between religion and national identity and its impact on religious freedom. And this is the extent to which public opinion and politics influence the judicial process. Both cases provoked intense reactions and mobilizations at both the grassroots and grasstops levels. On the pledge, the case that won the right of Mr. Nudau to take the case to the Supreme Court, it was a Ninth Circuit Court decision delivered in 2000, and that decision at the Ninth Circuit said that the teacher-led recitation of the pledge in public schools violates the Establishment Clause. So Nudau won the case at that level in 2000. The day after that case, the U.S. Senate voted unanimously to reaffirm the Pledge of Allegiance with the words "under God" in it. And the following day, the House of Representatives passed a resolution with a majority of 416 to 3, asserting that the Ninth Circuit Court ruling was inconsistent with the U.S. Supreme Court's First Amendment jurisprudence. Meanwhile, the then President George W. Bush called the ruling ridiculous and inconsistent with the traditions and history of America, end quote, and indicated that his administration would formally request of the Supreme Court an overruling of the Ninth Circuit decision. There's a lot more examples I could offer about the mobilization around that particular case. Similarly, in the Lautsi case, after the 2009 decision, when the Italian state sought referral to the Grand Chamber and the European Court of Human Rights, an unprecedented number of third-party interventions came from states, associations, and individuals, and they sought and won the right to intervene in the hearing with statements either for or against the original ruling. The interventions were in great majority against the ruling. 10 national governments, 33 members of the European Parliament, and 4 of the 10 intervening NGOs were all against the first ruling. Critically, in terms of the timing of the case, this was all happening in the context of an ongoing legitimacy crisis facing the European Court of Human Rights, yielding a reform process aiming, amongst other things, to limit the court's influence by emphasizing subsidiarity and the margin of appreciation allowed to individual states. When the European Court of Human Rights revisited the Lautsi case in the Grand Chamber hearing, the Grand Chamber moved from the 2009 unanimous decision to that was a 7-0 decision in favor of Lautsi to a 15-2 majority against. It's difficult to know for certain the extent to which mobilizations and lobbying efforts influenced the outcome of both court decisions in the pledge, in the case of the pledge and the crucifix, but an educated guess suggests that the influence was significant. My point is that states' handling of religious matters often reflects grassroots level demands, expectations, and mobilizations, which demands, expectations, and mobilizations are often embedded in predominant conceptions of religion in relation to national identity, and sometimes in nationalism infused with references to religion. The latter may then translate into these types of grasstops and grassroots mobilizations, openly seeking to influence court decisions. And these mobilizations are very often very effective. And depending on the topic at hand, some of you may say rightly so, and some of you may disagree. By way of conclusion, 1 minute or less, The religion-national identity link can be problematic for those seeking freedom of religion, as well as for those seeking freedom from religion. Probably the tension between the two will remain with us for a very long time. But fortunately, the divide is not absolute, and there are many who are working for both freedoms simultaneously in religious secular alliances such as those Slavica mentioned this morning. I'll stop there. Thank you very much for your attention.
That's perfect. Thank you so much. And I'd like to give one more round of applause and thank our panelists for today. Now we have about 15 minutes for questions. I'd like to remind you to speak into the microphone, to take a minute to introduce yourself, so the interpreters, if they need to, can switch to the appropriate language. Questions? Yes, Professor Yakovlevich.
Thank you, all three speakers. I'll just go with Effie this time. And my question is, it seems to me that from everything you said, the debates or the contentions are not just about religion. The contentions are actually about how to define national identity. And so I'm just curious if you can you disentangle all these elements in the way in which both secular and religious people are actually attempting to redefine or reappropriate different types of national identity in the European context. Thank you.
Please. Thank you for the question. It's a really good point, and it's a very contentious topic in these country contexts, particularly if you look at the level of NGO-prodded efforts to change the way that history is taught in public education. Because if you ask me what is the best way to address these problems, it's teaching national identity in a different way. If people from a very young age are taught to think of what it is to be Greek in a more open way, then at different levels, then a lot of these problems would be resolved. So all the efforts to change this type of education, conceptions of national identity, have come across really intense resistance. I can speak most confidently about the Greek case. There have been attempts over the last 10 years by many different groups, but also within the Ministry of Education, to change the public school handling of history, and especially, again, the way that the church is taught to be a fundamental aspect of Greek national identity, the Orthodox faith, and especially the church as responsible for keeping the Greek nation alive during the Ottoman Empire. And the church especially has fought these efforts really intensely, and it's very difficult to for politicians to overcome these. Not that many want to, but those who do want to move forward with the educational change are not managing very well, because there's a very strong lobby of theologians who are all taught in the Orthodox faith to teach history this way as well. They're teaching history courses, so it's a battle. It's a political battle, and I'd say that's the level at which it's being handled. So it doesn't get very far in the Greek context or in the others as well. But it's a good point. That's where it ought to. That's an important part of the solution of the problem.
Thank you. Other questions? Yes, Judge Wallace, please.
I would like to continue the questions that you brought up about the pledge case, and especially your conclusion, which I assume you believe, that in these cases such as this, that the political interests are successful in making modification. I'm having some difficulty with that. The reason in the United States Constitution for life tenure is to prevent such influence. And I don't know, I have seen nothing in the Ninth Circuit or in the Supreme Court that indicates it's had any help at all. The case that you talk about, the individual was dismissed in the High Court because of lack of standing, but it also was of concern that although he was an atheist, his daughter that he wished to represent was a born-again Christian. Those kinds of facts come out, and sometimes they raise some issues, but I don't see that it saw any issues, nor do I see that there was any pressure put upon the Ninth Circuit when Judge Alfred Goodwin wrote the majority opinion. It was a 2-to-1 decision. Judge Fernandez wrote dissent. Both the majority opinion and the dissent were excellent. On where is your research where the political process is successful in overturning an Article 3 judge in the United States on issues such as this? I'm going to the successfully, the term you used, successfully.
Thank you. No, I appreciate your question, and I hope we might get some more insight from you on this particular case. Now, I haven't read anywhere about influence on the decision of the Ninth Circuit. In the aftermath of the Ninth Circuit, there was a great deal of lobbying, and I've read a great deal about influences that the judges felt, complaints and pressures that the judges were feeling, and there are publicly published statements by the different judges about how distressed they were about all the politicization around the case. I can't prove, and no one can prove, how influenced they might have been by the pressures they were feeling, but whether these are publicly documented comments about how much pressure they were feeling. Like I said, no, I'm not talking about the circuit, I'm talking about the Supreme Court. I could give you the quotes, and they're published. So, I mean, this is not my own. I'm not trying to criticize the U.S. Supreme Court specifically. I'm just saying that judges can be under a lot of political pressure, and a lot of mobilization does tend to take place around certain nationally sensitive issues. But again, thank you for your comment.
Other questions? Yes, Professor Durham.
Hi, I'm Cole Durham, and I'm director here, so what can I say? I would like to ask Professor Elizabeth Shakman Hurd and Professor Jean-Paul Willaime, as I listened to the two talks, I heard different orientations toward how one thinks about, their broader issues, but how one thinks about training foreign policy personnel or teaching personnel. And what are they supposed to do? I'm very conscious that in many religious parts of the world, a secular orientation religious groups are feeling under attack from a secular orientation. And if the US State Department or if French schools take the position that we can't deal with religion because we're going to be privileging some or the other, then the implicit message is that a secular message is pressed. So how does this translate into practice as you try to train foreign policy personnel or train teachers?
Maybe, if you're willing, we'll start with you, Professor
Sure.
Hurd.
Do you want to finish? There was a second part.
Oh, is there a second part to the question,
Sure.
Cole? That covered it. Okay. Okay.
Yeah, so this is kind of the big conundrum. First of all, I hesitate because I think part of the problem is there's a certain kind of rush based on the assumption that now we're going to get religion, kind of like, get religion? Have you got religion? Yeah, we've got religion. And so then there's a precipitous rush to implement programming at state and elsewhere. I think I named a few other agencies and departments across the government. This is really quite a comprehensive effort that will somehow reflect the fact that suddenly now we know what religion is, we know who's going to speak on its behalf, and we know how it's going to be a part of conversations and decision-making processes. And my point is really pulling back from what you said. I'm not that concerned about who's secular and who's religious. My point is that inevitably we need to understand that this involves a form of establishment. This involves processes of selection. This involves selectivity. This involves deciding who speaks for a particular community and exactly who's allowed to speak for a particular community and who they're understood to represent. And in terms of the religious literacy or religious education question, this is a very big issue, and I think it's something that we all need to think more about, because I don't think that there's a simple answer that there can be a set of curricular materials or a particular course that can be offered to suddenly fix the problem, and that I don't think it's that simple. So I'm very, very hesitant to jump into this minefield. But I have to say that I don't buy the story that that there are all these religious groups all over the world that are being oppressed because the U.S. won't engage with them. I think the U.S. should engage with people based on all kinds of, civil society associations and identities, but I think that when the U.S. singles out religion, it inevitably sets in motion a particular kind of dynamic, a particular set of political processes that I spent some time talking about in my presentation and won't belabor here. But I think that we have to recognize that that is what happens when we privilege religion as a category in public policy making, and that may be a price that clearly is today that people are willing to pay, but I think that we need to be aware of what we're doing as we move forward on that front. Thanks.
Thank you. Professor Willaime?
The question is first the question of the legitimacy for the secular public school. You can think that secular public school has nothing to do with religion because it is secular. But in the secular approach to religion, the Debray report argues that it is a necessity for the public school to approach, to study religious phenomena as other social, cultural phenomena. Thus, a question of to bring knowledge about religions, to bring how to understand practices, rites, and religious behavior, about one religion and about other religions, but not from a religious point of view, but from an historical, sociological point of view. It was a little bit a revolution, the French secular state school, to open the curricula for the pupils with integrating knowledge about the different religions. For example, in a French college, there were pupils, Muslim pupils, who said to the teacher, "You have no right to speak about my religion, because I have the teaching of in the mosque." The answer of the teacher was, "I have right to speak about your religion, because it's a part of history, it's a part of culture, and it is not in a confessional religious perspective, but I have right to bring some knowledge." And it's very useful. For example, some pupils refuse to visit religious house, religious churches, mosques, because this is not my religions. But by the professor in history, professor is foreign language, the professor can bring the students to visit different places of worship. And I think it's an original and necessary contribution to the secular school in the field of religions. And at the beginning of this move in the French school system, two critical reactions from religious voices who said you cannot have a very right approach to religion in school. And from the secularists, the activist secularists, it's a comeback of religion in school. But two opposite critics. And the answer was, it is not a comeback of religious in school, and we have right to speak. The religious phenomena are too much important. It is not only the religionists who have right to speak about religions. and in different disciplines, the professors have right to speak, to study, to tell, to explain religious phenomena, and it is the choice made in the French secular school.
Thank you. I think our time is up, but we encourage you to continue the conversations during the break. After the break, we'll have a session here on China, and this is where the Asian language interpretation will be. 205 in Mexico, downstairs, where Spanish and Portuguese. Australia, downstairs in 206. And then immediately behind me will be Middle East and North Africa, which is where right now we have the European languages set for translation. Please join me one more time in thanking our panel.